Hello, my name is Melissa Keys, and I am the Legal Director for Indiana Disability Rights. I have a master's degree in clinical psychology with a focus on developmental disabilities and serious mental illness, and also a law degree. So today I am going to cover some basics on decision making and then focus on options that are available to adults to assist them with decision making, specifically spending some time on supported decision making, using Jamie Beck's case as an example. And then finally, we will end with how you can help to make sure that people are receiving the help that they need in the least restrictive manner possible. So let's start out really simple. We've all made decisions. In fact, we make hundreds, if not thousands, of decisions every day. What to eat, what to wear, whether to answer that snarky email with an equally snarky email. The decisions we make range in their complexity and the time and mental resources we use to make them. For example, the time and energy it takes for you to decide what to eat for breakfast is different than the time it takes to make a bigger decision like where to live. And regardless of the type of decision we make, the process is still the same. It involves understanding the issue, determining the options and consequences, gathering information, evaluating those options and consequences, deciding on a course of action, communicating or implementing that choice, and then experiencing the consequences of that choice. Now, sometimes this process is instantaneous. We don't even realize we're doing it, like with, deciding what to wear. Other times we are much more deliberate. We talk to friends and family. We talk to trusted professionals. We read Amazon Prime product reviews. We do whatever we need in order for us to feel comfortable in making an informed choice. And we are empowered to make those choices and have our decisions respected. And this is part of the natural human experience. Now, we've all had experiences, even as adults, where someone has made a choice for us, right? For example, you want Mexican for dinner, but your partner orders Chinese. Even those small choices, when we feel like we haven't been heard or that our choice hasn't been respected, can make us feel frustrated. But think about the big decisions in your life, what job you have, where you live, how to spend your free time. Imagine how it might feel to not be able to make choices about these important areas of your life or to not have input. So, in its most basic understanding, supported decision-making is a way to accommodate the decision-making process that we just talked about. In supported decision-making, people who need support choose supporters. These are generally trusted friends or family members or caregivers to help them through that decision-making process. However, with supported decision-making, or SDM, the person has all the decision-making authority. It's a way to increase empowerment and assert self-determination. As we've discussed, the concept itself is not new. It's kind of how most of us make major decisions anyway. But the formalization of it, or writing it down, or having that decision be recognized as a valid way for a person to make a decision has just recently started to take hold across the country. So we can expect to see and hear more about this topic in the next several years. So who can use supported decision-making? The short answer is anyone can use the principles of supported decision-making, but the answer is a little bit deeper than that. So the concept of SDM, it can be used by anyone to maximize participation, even for someone who's currently under guardianship. And while the concept really started with people with intellectual and developmental disabilities, it can be used for any disability or condition, including those with mental health issues, those recovering from addictions, and conditions of aging. And I want to talk briefly about this issue of capacity. There are, of course, different legal standards for capacity. There's capacity to consent to medical treatment, capacity to contract, capacity to sign a power of attorney. And it's important to note that capacity really exists on a spectrum, right? Whether someone has capacity is determined not only by the situation, but also the complexity of the issue, as well as internal and external factors, time of day, physiological state. For anyone who has ever gone grocery shopping while hungry, you understand that you make different choices than you do when you're not hungry. Timing of the day is also important. You ask me a question before 8 a.m. and you're going to get a much different answer than you will at 10 o'clock at night. And it also relates to the person. Their alertness may change based on when and what type of medication they've taken, or how much sleep they had the night before, or whether they're currently experiencing symptoms of their diagnosis. Capacity can also change over time based on skill acquisition. The more you learn or practice a particular skill, the better you are at it. And the same is true for decision making. And here's kind of an example. So I have a driver's license. This means that the state of Indiana has said that I have the basic capacity to drive a car. In order to demonstrate that, I didn't need to prove that I knew everything about how a car engine was built. I didn't need to drive like Danica Patrick around the Indy 500. I just needed to meet those minimum requirements to show that I could drive safely, right? Now, my driving skills have, for the most part, gotten better than they were when I was 16. And there's also advances in technology that has made it easier and safer to drive. But even within that, my capacity to drive fluctuates. Driving late at night in bad weather with my kids screaming in the back seat, asking for snacks, is much different than driving on a clear day with no distractions. But the state of Indiana hasn't put restrictions on my ability to drive. They haven't said, you can only drive when you aren't distracted on clear sunny days. And they also haven't said, you need to be able to rebuild a transmission in order to be able to drive. It's understood that I can regulate my behavior. I can seek help from those who have more expertise in certain areas that I'm not aware of. I can consult a mechanic. But the same, unfortunately, isn't always true for decision making. Oftentimes, people with disabilities have to prove that they can make decisions covering a wide variety of areas and complexity at all times and under many different circumstances in order to maintain their ability to make decisions independently. And the point is, when we talk about capacity, we really need to think of it as a spectrum, not a yes or no, where there's this magical line that you cross from having capacity to not having capacity. There's all kinds of different factors that go into a determination of whether someone has capacity to make decisions themselves. So, many people have been in a meeting where someone has said, once your child turns 18, you'll have to get guardianship, or else you won't be able to participate in their, whatever, educational decisions, medical decisions, service decisions. It happens a lot. And with very, very limited exceptions. There are no services or supports or benefits that require someone to be under guardianship in order to access them. And I want to make sure everyone is aware that there are options other than guardianship. Now, don't get me wrong, guardianship is definitely a necessary tool. But for those who are just getting guardianship to be able to participate in a loved one's life, there are other less intrusive ways to do that. Our goal here is to make sure that everyone has an opportunity to participate and make decisions about their life to the greatest extent possible and in the least restrictive manner possible. And for many people, that's not an unfamiliar concept. So let's talk briefly about the different options for how we can help support people, keeping in mind that many of these tools can be used in combination. They can change over time to really individualize the supports based on the person's strengths or needs. For those of you who are like me, are visual learners, this is what I call the spectrum of assistance, going from least restrictive all the way on the left to the most restrictive. So starting with the least restrictive, talking about independence or interdependence as well as informal supports, these would be ways to help fill the gaps in someone's needs. So for example, someone who has a hard time remembering to pay bills, setting up automatic bill pay, or using credit cards with low limits, or store-specific gift cards for those who need help with budgeting, using an app or a smart medication dispenser, using a calendar application or paper calendar to help people keep track of their appointments and when they need to remember to do things. There's even, all kinds of smart home technology to help people live independently, where they can lock their doors remotely if they forget to do so, or they can monitor to make sure that the house is still safe. And really, creativity is key here. It's anything that can be done with minimal involvement or intrusion into someone's life to help support them. Next, we have formalized supported decision-making. which again is a way to accommodate that decision-making process that we talked about that still allows the person the ability to make the decision themselves. The person chooses not only the areas where they need support, so for example, finances or health or legal matters, education, employment, community living, really anything that they'd like. The person also chooses his or her supporters, and those are generally trusted friends or family, and they also choose how they want that support to be given. For example, giving the person information in a way they can understand, or discussing the pros and cons of a particular choice, or being there to help them brainstorm or understand questions that they might want to ask their doctor. Any way that the person decides that they need help, they can account for in their supported decision-making agreement. So the formalization of supported decision-making generally means writing down the person's plan or accommodations into a document called a supported decision-making agreement, which we'll touch on briefly in a moment. These agreements can be changed as needed. They don't require a court to get involved, and they can be very flexible to change with the person's change in circumstances. Next are agency agreements, where a person has the capacity to appoint someone else to make a decision on their behalf. This is what you typically think of for things like powers of attorney or healthcare representative or representative payees. Depending on how the document is written and the type of document, the person delegates their decision-making authority to someone else. These can generally be revoked by the person. They also generally do not require court oversight or involvement. And they're sometimes just a good practice to have in place for anyone as part of, general advanced planning. And for most of these, it would be really wise to consult with an attorney to make sure that the document complies with Indiana law and that it's drafted in accordance with the person's wishes. Now, looking at limited guardianships and guardianships. Guardianships are a legal process involving the courts. That is the only way to get guardianship is going before a judge. There are different types of guardianship, but I want to be clear about what it is. There are considerable rights removed from the person, as the guardian essentially stands in the legal shoes of the person over whom they are guardian for. It is generally used when a person can no longer make or communicate decisions about their life or their property. Like I said, guardianship is definitely a necessary tool, but for those who don't need that higher level of intervention, there are much less restrictive ways to give the person the support that they need. So limited guardianships are guardianships generally over just the person, meaning they deal with issues about where they live or medical treatment, or over their estate, which deals with property, assets, finances, that type of thing. In the areas covered by the limited guardianship, the guardian makes all the final decisions, but the person retains decision-making authority in all the other areas. There are also things like temporary guardianships, where a court can grant decision-making authority to someone for a limited amount of time. And then full guardianship means that all decisions, both person and the estate, are made by the guardian. Guardianships can be really difficult to terminate because it does involve court oversight. The only two ways to get out from under a guardianship or to remove a guardianship is if the person under guardianship passes away, or if you make a showing to a court that the person has regained capacity. That generally involves having to call an expert or a medical provider that can speak to the person's abilities to make decisions. That's why it's really important to start with the least restrictive option possible and then move up from there, as opposed to starting with the most restrictive, because it can be much harder to walk back if that type of intervention is no longer needed. And I just wanted to note briefly, there are other decision-making models out there. There's something called shared decision-making or team-based decision-making, where the decision is made by the person in coordination with others. You'll often think of this in the treatment planning realm. There's also shared decision-making in the medical context to help promote informed consent. There's also other decision-making support arrangements. There's trust accounts, protective orders, advance directives, living wills, psychiatric advance directives. People should really be encouraged to talk to an attorney who specializes in this area of law so that they can discuss all of the different options that are available. And the other thing that I want to note again, is the concept of supported decision-making, of accommodating and supporting someone through that decision-making process, can and should be used throughout any of these other options. Even within the guardianship context, it can be a way for the person to gain skills in decision-making, which could lead to less of a need for a guardian over time. I want to briefly focus here on the difference between powers of attorney, supported decision-making, and guardianship. So powers of attorney are really useful tools. We talked about them kind of briefly, but in essence, and depending on how they're drafted, they give decision-making authority to an agent called an attorney in fact. They can be written to address a number of circumstances. They are flexible, they're regulated in Indiana law, but they differ significantly from supported decision-making in one major way. So in supported decision-making, the person retains decision-making authority. The person works with their supporter, but ultimately they make their own decision. There can be a tendency, even with the most carefully crafted power of attorney, to assume that the attorney, in fact, has been granted decision-making authority and to default to them to make a decision. Supported decision-making, on the other hand, it's an entirely different notch on that spectrum of assistance that we talked about. It does not grant anyone decision-making authority. It just structures that decision-making support that the person needs in order for them to make their own decisions. And then, of course, guardianship is where a court appoints someone to make a decision on your behalf. So if you think about it, supported decision-making is basically, I make decisions myself using my supporter. And then a power of attorney is, I appoint Bob to make decisions for me. And then guardianship is, a court has appointed Bob to make decisions for me. So one of the biggest questions I usually hear about supported decision-making is what protections are in place to keep people from making quote-unquote bad decisions or to keep them from being abused or neglected or exploited. So I want to address a few of those concerns. So decision-making is not a skill that we are born with. Anyone who has spent more than 5 minutes with a child knows that it takes time and experience in order to really cultivate our decision-making ability. Here's an example. In college, where we all know that great decisions are made, I decided to test fate by seeing how long I could go with my tank on E. It didn't really start out that way. I was late for class, I didn't have time to stop, and then I was in a hurry to get home, but I went like 2 or 3 days with that needle just pushing it on the E. Finally, off campus on my way home, my car died. So what should have been a $20 fill-up a few days ago turned into a $75 tow to a gas station, a $20 fill-up, and a really embarrassing phone call to my parents. Now, after this incident, the state didn't take my license away or say that I can't drive anymore. They didn't condition my driving on always having a half a tank. No, I was able to learn from my mistake and move on. I had that dignity of risk. Unfortunately, people with disabilities are often not given that same dignity to make mistakes, and they may find themselves in a position where their ability to make mistakes is questioned for quote-unquote bad choices that many of us have also made. And most of us have heard or have said the phrase, well, he's an adult, he can do what he wants. And you'll notice that you never say it when someone is making a quote-unquote good choice. It's not, Bob sure is saving a lot of money lately. Well, he's an adult, he can do what he wants. No, we start to question someone's choices, not based necessarily on their ability to make decisions, which is, understanding the choices available and the consequences of those choices, but rather when someone is making a decision that we don't agree with. There's that value base to it. And here's kind of an example. So my dad has smoked a pipe his entire life. It's a gross habit. I don't agree with it. It's unhealthy. It's expensive. It's just generally icky. My sisters and I constantly told him to stop smoking. My mom, his doctors, friends, coworkers, everyone has said, you really should quit smoking. But no one has ever said you're making an unhealthy choice that a reasonable person wouldn't make, so I'm going to get guardianship over you because it's clear that you can't make decisions related to your health. That's silly. But unfortunately, people with disabilities are often held to that higher standard. They don't get that dignity of risk. They don't have their choices respected automatically by doctors or service providers. And they tend to have their decisions questioned and their ability to make decisions questioned more often than people without disabilities. And this burden of low expectations is that we assume that people with disabilities, they won't make good decisions, or that they don't know how to make a decision, so we don't even give them an opportunity to do so. And then we're surprised when they make a quote-unquote bad decision, and we have this knee-jerk reaction like, well, that didn't work, I guess they can never make a decision again. It's not how we treat, the general population, and it's not how we should treat people with disabilities either. Most of us would probably not want our decision-making skills evaluated based on decisions that we made when we were 19. And people all deserve that same dignity of risk that we all enjoy. So rather than putting this high standard of, you've got to make good decisions or else you need to have a guardian, or have someone make decisions for you, there are ways to lessen the risks that people face in a much less restrictive way than jumping straight to guardianship. So for example, some of those alternatives that we talked about earlier. Here's another secret. Guardianship is not an impenetrable shield. It is not a chastity belt. It is not a bank vault. It will not force someone to take their medication or stay in a facility or what have you. Bad things can and do happen. It's unfortunately part of the world that we live in. There are far too many anecdotes about guardians and attorneys, in fact, behaving badly. There's no guarantee of safety under any arrangement, but that's not a reason to limit the options that are available to make sure that people have the choices to live their best lives. So instead, people should be empowered to use their voice, have their voice respected. So that means if abuse, neglect, or exploitation does happen, having their stories believed and holding the perpetrators accountable. And studies have shown that those who are empowered, those who have the ability to make their own decisions or have their voices heard, are actually much less likely to experience abuse, neglect, and exploitation. Learned helplessness, on the other hand, like what happens when someone is not allowed control over their own life, can be associated with an increased likelihood of exploitation or abuse or neglect, as well as increases in symptoms of depression, anxiety, and loneliness. It's much better to teach someone how to identify toxic, abusive, or exploitive behavior than to rely on someone always being around to do that for them, because eventually they won't have a person in their corner, or worse yet, they'll have the wrong person. Supported decision-making also has this added bonus of oftentimes having a team involved. There's often several supporters named, and they can act as checks and balances to make sure the person's not being abused or neglected or exploited. And then I would remind you that with supported decision-making, that person retains the right to make all of their own decisions. So that means that no one else is allowed to make decisions for them, unlike with agency arrangements and guardianship. And that's huge in being able to support someone's self-determination and is a good way to guard against abuse, neglect, and exploitation. And lastly, Indiana does have a mandatory reporting requirement, so anyone who does become aware of abuse, neglect, or exploitation is required by law to report that to the proper authorities, whether it's law enforcement or adult or child protective services. So getting back to supported decision-making agreements, we've talked a lot about how this concept of supported decision-making is what we inherently do anyway when we are making decisions. Now, when you're deciding what kind of car to buy, do you write down, I'm going to talk to my brother and I'm going to consult with Kelley Blue Book and I'm going to go to these 3 different dealerships? Probably not, but for those who need some additional support or structure, that might be a really needed tool. So currently in Indiana, supported decision-making agreements do not need to be on a special form. Now, we have developed a form as part of our project. Anybody who's interested in that can feel free to go to our website. There's a link to that on the resources slide at the end of this presentation. But these agreements not only provide a reference point for the person who needs support, but it also provides structure to the supporter. And it can also, most importantly, be used to show third parties like doctors or service providers who may be questioning someone's ability to make decisions that they are, in fact, able to make their own decisions and have those decisions be recognized, even if they are using accommodations in that process. Some common components of a form include an acknowledgement of the way the supported decision-making relationship will work. There's identification of the supporters, the areas of the person's life where they want support, and then the manner by which they want support to be provided. There's also generally a way to reference any other decision-making arrangements or support that the person wants referenced. So for example, if they have a representative payee or a trust account. And then there's usually an acknowledgement by the supporter so that they make sure they know their role and their responsibilities. And lastly, the form is generally signed and notarized or witnessed. And then at least on the form that we have as part of our project, there's also a reference to the mandatory reporting requirement. So next I want to talk to you about my friend Jamie. In 2010, Jamie was found by Adult Protective Services wandering around the town of Economy, Indiana, all by herself. Her father had passed away 3 days earlier at a local hospital, and Jamie had no other family members to care for her. APS, or Adult Protective Services, placed Jamie in a local nursing home, and she was appointed a guardian. Now, while in the nursing home, it took Jamie over a year to get a CIH waiver, after which time she moved into the community, into a waiver home. She began working in a sheltered workshop, but she wanted something different. She tried to find a job, but she ran into problems because she only had a certificate, not a diploma. Jamie was able to advocate for herself in front of the Richmond City Council, and she got a job in the community, but she wanted a full-time job, and so she applied for training at the Erskine Green Training Institute in Muncie. Before graduating from that program, she had a full-time job offer from Ball Memorial Hospital, making $11 an hour with benefits. During this time, Jamie's guardian brought her to our project in order to terminate her guardianship in favor of supported decision-making. I met with Jamie, and together we helped draft her plan, and we worked with her supporters. And then on June 13th, 2018, we went before Judge Gregory Horn, and we successfully terminated Jamie's guardianship, making her the first person in the state of Indiana to utilize formalized supported decision-making. Some things to note about Jamie's case. It's just, imagine being in a nursing home at age 19, and it really kind of shows the failures that are possible in the system. The fact that she graduated from high school and wasn't connected to services after that. And when she wasn't connected to services, she may have likely been in need of a guardian. Obviously, if she's wandering around the street by herself, she needs someone to step in and help make sure that she is taken care of. But after she gained skills in decision making, after she got connected to resources, she no longer needed that level of intervention. But in order to get out from under the situation that she was in, it took a lot of time and effort and resources to make that happen. And the other thing to keep in mind is the importance of the guardian. Under a different guardian, it could have ended up in a very different situation. So luckily, her guardian was very supportive of her living in the community and working in the community. But had she had a different guardian, that guardian may have said, oh, well, she is safe and sound in the nursing home, so she'll just stay there and let me know if you need anything. And Jamie might very well still be there to this day. So it's important to think about long-term the options that are best for somebody, and think long-term about who to have as supporters in that first place. Now, how do you fit into this discussion? So talking to the people that you love in your life early and often about the different options, pushing back if you hear people encouraging guardianship, if a less restrictive alternative might work, encouraging opportunities for decision making, building decision making into goals or programs, adding in options in ever increasingly more complex decisions, so giving people opportunities to fail as well. Encouraging the person to be an active participant in their meetings and supporting their decisions. And then finally, I wanted to briefly mention the supported decision-making legislation that's currently before the Indiana General Assembly. It's Senate Bill 380. And that bill does a few things. First, it would allow for supported decision-making agreements to be recognized as valid ways for someone to make a decision. And second, it would require petitions for guardianship to include a statement about whether less restrictive alternatives have been considered. It doesn't require that they be tried, but it just that they have been thought about. And then three, it would require, in the biannual accounting that guardians are supposed to do and submit to the court, it would require guardians to provide additional information on whether guardianship is still necessary or if a less restrictive option might be better. I want to do a little plug for some different resources. Indiana Disability Rights, we have recently launched a page dealing specifically with supported decision-making and guardianship issues, so feel free to take that out. I would also encourage you to check out the Jenny Hatch Project. That is an organization that promotes the use of supported decision-making and celebrates Jenny Hatch, a woman with Down syndrome who was the first person in the country, really, to have her guardianship terminated in favor of supported decision-making. And if you have the opportunity to read about her story, it's a fantastic one. And then finally, I will leave you with my specific contact information. You can feel free to reach out to Indiana Disability Rights if you have any additional questions or comments about different options available in adulthood. And with that, I thank you for your attention, and I hope that you have learned a lot of different things about different options for guardianship and decision-making in adulthood. Thank you.